Hi, my name's Amirul, and today we're going to dive into a commonly asked question when it comes to employment law. An employee who believes they've been unfairly dismissed has a right to file an unfair dismissal complaint against their employer. However, how do these complaints work, and what normally happens in an unfair dismissal claim? Under Section 20 of the Industrial Relations Act 1967, an aggrieved individual must file an unfair dismissal representation to the Director General of Industrial Relations. This can be done by filing certain forms at the Industrial Relations Department, which can be downloaded at their own official website. However, the time limit to file a complaint is 60 days from the last day of employment, failing which no complaint will be entertained. After the forms are filed, the department will schedule a conciliation meeting and inform both the employer and employee. The purpose of this meeting is to see whether parties can resolve this dispute amicably without going to court. No lawyers are allowed at the conciliation meeting. There are three possible outcomes from the meeting. First, reinstatement for the employee. Second, financial settlement, or no settlement at all. If parties are unable to settle the dispute in a conciliation meeting, the department will then refer the matter to the industrial court for determination. When a matter is referred, the industrial court will issue a notice to both employer and employee informing them of the first court date, or also known as a mention. At this stage, parties can be represented by lawyers. A mention is an administrative court date issued by the court to parties to file in their respective documents known as pleadings. These documents will provide info on the employee's alleged unfair dismissal claim against the employer and the employer's response to the statements made by the employee. Pleadings are broken down to three separate documents: statement of case, statement in reply, and a rejoinder. Parties will also be required to file a bundle of supporting documents as well as their own witness statements. A date will then be scheduled by the industrial court to hear the matter through trial. Witnesses will come to court to testify, and documents will be produced by each party as evidence in relation to their own arguments. After the hearing of the trial is completed, the industrial court will ask parties to file in written legal submissions. These legal submissions are essentially a brief as to why the court should dictate in one party's favor. These legal submissions will consist of summary of the evidence produced, case laws, as well as legal authorities. After the legal submissions have been filed, the industrial court will deliver its decision through what we call an award. However, the award will not be delivered instantly. There is no fixed time for the industrial court to deliver its award. Parties will be notified when the award is ready. So this is a brief explanation as to what happens in an unfair dismissal claim. An unfair dismissal claim is always a serious matter, regardless whether you're an employer or an employee. In areas of doubt, always seek professional legal advice. Until then, see you next time.